Jake Sherman is co-founder of Punchbowl News and an MSNBC political contributor. With me in studio, MSNBC legal correspondent Lisa Rubin and former federal prosecutor Paul Butler, who's a law professor at Georgetown and an MSNBC legal analyst. And we want to get to all of that. But Lisa, we just got word that Ghislaine Maxwell's attorney has filed a reply brief in Maxwell's months-long appeal before the Supreme Court. What did we learn?
We didn't learn much, Chris, that we didn't already know, and that's because a reply brief, by definition, isn't supposed to raise new issues. But for people who are unfamiliar with Ghislaine Maxwell's appeal to the Supreme Court, it raises only one issue, and that is whether Ghislaine Maxwell's prosecution by the Southern District of New York, starting in 2021, should have been precluded by the agreement that Jeffrey Epstein struck with prosecutors in Florida in 2007. She says that that agreement should have bound all of DOJ for all time from prosecuting her because it covered co-conspirators of Jeffrey Epstein, including but not limited to 4 named individuals, none of whom were Ghislaine Maxwell. But that is the only issue on appeal to the Supreme Court. And obviously the other part of it is now that the briefing is complete, the Supreme Court can act at any moment to either deny review of Ghislaine Maxwell's conviction or to schedule it for argument and briefing in the fall.
So while we wait for that, and as you say, it could come any time, Paul, this idea that Todd Blanche asked Maxwell about 100 people certainly grabbed a lot of attention, right? But does that sound like someone who is not leaving any stone unturned or someone who maybe is on a fishing expedition?
It sounds like the Deputy Attorney General is on a fishing expedition to see whether Ms. Maxwell has the goods on Democrats, which is what President Trump is saying that the investigation should be about. It's clearly not about any further exposure by Ms. Maxwell because she's been giving immunity. The question is, if Ms. Maxwell really has new information, why is this just coming up now? Typically, when defendants, including convicted folks, agree to talk to the government, it's because they're trying to get a lower sentence. It's often part of a plea bargaining process or something that comes up before sentencing. So why now? Ms. Maxwell, in every legal proceeding, has maintained that she had no idea that Jeffrey Epstein was a sex predator, that she didn't even know that there were any underage girls on the property but for one employee. So the question was, is she lying? Was she lying in all of those other court proceedings, or is she perhaps lying now to try to get in the good graces of the Department of Justice?
Jake, asked about the possibility of a pardon on Sunday, Speaker Johnson said he didn't want to get ahead of any decision by President Trump, but then he added this.
If you're asking my opinion, I think 20 years was a pittance. I think she should have a life sentence at least. I mean, think of all these unspeakable crimes. And as you noted earlier, probably 1,000 victims. I mean, you know, it's hard to put into words how evil this was.
We already knew, Jake, that there was this problem in tamping down the conversation about it. But to the conversation itself, has that even gotten trickier for Republicans? That in many ways, the more they get out there, oh, she's talked to 100 or she talked about 100 people, the more questions it even raises.
Let's talk about this from Mike Johnson's point of view. He's leaving himself zero wiggle room here, zero. And if Trump were to pardon Ms. Maxwell, it would be quite embarrassing because the Republican leadership on Capitol Hill is very hesitant to be seen as doing anything contrary to Trump's wishes or wants. And Johnson is right in that he doesn't have a role in this, but he's the leader of the Republican Party on Capitol Hill, and he's expected to have a view. And to be honest with you, of all the issues that we've seen during the Trump years, the flare-ups, this is among the most vibrant, let's call it, the issue over Jeffrey Epstein and releasing the documents. We've never seen House Republicans go against the president as they have when it comes to Jeffrey Epstein and the so-called Epstein files. So one of the most combustible issues that I've seen on Capitol Hill in a long time.
And you see many of his supporters trying to explain away some of the things that have happened, or let's say offer an alternate theory. Take the case of Republican Mark Wayne Mullen, senator, and his conversation yesterday with Jake Tapper. Take a listen.
2009, there was a sweetheart plea deal that was made underneath the Obama administration with Epstein.
Right. That's not
and that sweetheart has not been exposed.
No, it was 2000.
Not? Well, when was the case heard?
It was 2008. It was the U.S. attorney at the time was a guy named Alex Acosta. He was a Bush appointee. He went on to become President Trump's Secretary of Labor. It all took place in 2008.
Who was in office at the time?
2008, George W. Bush.
Who was in office at the time?
George W. Bush.
No, 2009 is when the case came out, and it was and Obama was in office at the time.
It's not true.
So, Jake, are Republicans basically at the mercy of legal developments and the DOJ, or alternatively, they just have to put forth a narrative that is easy to fact check as false?
Yeah, I'm not really sure where Mullen was going there. I mean, this is like a Wikipedia-able fact to look up. It was Mr. Acosta who did go, hey Siri or something like that. You could look this stuff up. Mullen has been among the more stauncher defenders of Trump's handling of this case. I mean, but he's an outlier, to be honest with you. I mean, you see Trump allies, especially in the House, having basically no patience for these documents continuing to be secret. So they're not as much at the mercy, to be honest with you, as a whole, as Senator Mullen is indicating he is right there.
Jake Sherman, thank you for that, which brings me to you, Paul. And we learned last week that the DOJ had done this, yet another exhaustive read-through, search through these files. The Washington Post now says this, quote, after concluding that fewer than a tenth of those documents could be considered for release, staffers were asked to go through them at least 4 times more. The ultimate result had seemed obvious to many of those involved from the start. It was memorialized in the Epstein memo. There was no unreleased evidence that would expose any additional third parties to allegations.
In a significant development in the ongoing legal saga surrounding Ghislaine Maxwell, her attorney has filed a reply brief in her months-long appeal before the Supreme Court, focusing on a singular issue: whether a 2007 agreement between Jeffrey Epstein and Florida prosecutors should have barred her 2021 prosecution by the Southern District of New York. The agreement, which covered Epstein's co-conspirators but did not explicitly name Maxwell, is at the heart of her argument that the Department of Justice, DOJ, was bound from prosecuting her. With the briefing now complete, the Supreme Court could rule at any moment, either denying review of Maxwell's conviction or scheduling arguments for the fall, keeping the case in the public eye. The appeal comes amid speculation about Maxwell's intentions, with some suggesting she may be leveraging her testimony to secure favorable treatment, potentially even a pardon, from President Donald Trump. This speculation intensified after reports surfaced that Deputy Attorney General Todd Blanche questioned Maxwell about 100 individuals, prompting questions about whether this was a thorough investigation or a politically motivated fishing expedition. Critics argue that Maxwell, who has consistently denied knowledge of Epstein's predatory behavior, may be fabricating new information to curry favor with the DOJ. Legal analysts point out that such cooperation typically occurs before sentencing to secure a lighter penalty, raising doubts about the timing and credibility of any new disclosures. Maxwell's claim that she was unaware of Epstein's activities, including the presence of underage girls, has been met with skepticism, given her conviction for grooming victims and participating in some of the assaults. The political dimensions of the case have further complicated the narrative. House Speaker Mike Johnson, a prominent Republican, has publicly stated that Maxwell's 20-year sentence was insufficient, advocating for a life sentence given the scale of her crimes, which potentially impacted over 1,000 victims. His comments underscore the delicate balancing act for Republican leadership, who are wary of contradicting Trump's potential decisions, including the possibility of a pardon. Such a move could prove embarrassing for figures like Johnson, who have taken a hardline stance against Maxwell. The broader Republican response to the Epstein case has been notably contentious, with some House Republicans pushing for the release of the so-called Epstein files, marking a rare divergence from Trump's position. Missteps by some Republicans have added to the controversy. Senator Markwayne Mullin inaccurately claimed that a 2009 sweetheart plea deal for Epstein occurred under the Obama administration, when it was actually negotiated in 2008 under President George W. Bush by then U.S. Attorney Alex Acosta, a Bush appointee who later served as Trump's Secretary of Labor. Such factual errors have fueled criticism that some Republicans are crafting narratives to deflect scrutiny, which are easily debunked. Meanwhile, exhaustive DOJ investigations, including multiple reviews of Epstein-related documents, have concluded that fewer than a tenth of the files could be released, with no new evidence implicating additional third parties in wrongdoing. The New York Times reported that thousands of hours spent combing through evidence yielded no leads for further charges, casting doubt on claims that Maxwell possesses undisclosed information. Legal experts question the likelihood of new revelations, given the consistency of victim testimonies and Maxwell's long-standing denials. A pardon, they argue, would be difficult to justify given her active role in Epstein's crimes. As the Supreme Court deliberates and political tensions simmer, Maxwell's case remains a flashpoint, raising questions about justice, accountability, and the intersection of law and politics. The outcome of her appeal and any potential cooperation with authorities will likely shape the ongoing discourse surrounding one of the most high-profile criminal cases in recent memory.